Hello, my name is Tina Schenk. Today we're doing a MUWE webinar, part 1. First lecture in a series of lectures on various topics and that relate to musicians and composers specifically. Today I'm doing a little introductory lecture on copyright, and I thought maybe this is something that could be useful for more musicians than just me. Now, I'm a lawyer by training, so I have done some research into this. And I think it's going to be useful, especially now in these days of the internet, where people don't seem to know much about copyright anymore. So, this is going to be part 1. Stay tuned in about a month's time for part 2, and I hope you enjoy it. Okay, copyright. What is it? We do have a more or less common concept of copyright in the world, but I am going to define it now for us. It's the right of the creator to decide all the aspects of their creation, such as distribution, public performance, and consumption. There are different categories or conceptual wordings around the world, and in Anglo-American law specifically, copyright is often regarding commercial interests, whereas authors' rights concern ideological interests or ideal interests. However, we are just going to be using the more or less international understanding of copyright as the definition that I just put on the screen. So everything that the creator has as rights to decide over their work. In music, there are different types of copyright that we should be aware of. This is you. You have a bright idea, and some music comes out of it. This is the right that you have as a composer or a producer of the original piece. So composition, the process of composition, and the results of a composition is one category of copyright that you should be aware of, that defines the rights of the creator. Now, this is you again, and this time you want to perform the music you composed. The performance is covered by a different type of copyright, where the actual performance, not the piece in itself, but the actual performance of the piece is protected. You also have a type of performance in the fact that you just made some music in your DAW. So the idea of the music is a composition type copyright, whereas the actual sound that comes out of the DAW is a performance. So those two things are protected by different types of copyright. There's a third one that mainly regards the recording, which is also sometimes known as the master rights. And this is what record labels typically hold when they have any right to any piece of music at all, which is most often. But that right is usually tied strictly to the recording. So that's something to be aware of, that your situation as an individual composer making some music in your DAW and then recording it falls into 3 different categories of copyright: the composition category, the performance category, and the recording category. The legal basis for copyright in international law is international treaties, which govern the principles of copyright and decides what the principles are going to be. The main one in the world is called the Berne Convention, and all UN members and all the countries who want to be UN members are parties. This means that most of the states in the world are parties to this convention. There used to be another one called the UCC, which governed the US and Latin America. But nowadays, those countries have become parties to the Berne Convention, and there are only a very few elements of copyright that are still being governed by the UCC. Another source for copyright government is national law. And in national law, you will find details about how the copyright is going to be enacted in your country. And also a lot of the rules, specific rules about exemptions and form. So it's worth checking what the law is in your country. And you can usually easily do this by looking at a website for your country's specific legal sources and just get the act or the law from there. And I suggest you do give it a skim. There should be some summaries here and there. Now, what is actual copyright? What are your rights as a composer? There are two types of rights. One is tied to practical elements. So there are certain practical aspects, like you have the right to perform your piece. You have the right to monetize on your piece. You have the exclusive right to modify and or arrange your piece, which includes covers. So that's going to be a topic for a different lecture, but covers are also your exclusive right as a composer. And you have the right to distribute and broadcast your work and decide how it's going to be distributed and broadcasted. So your other type of right as a composer is something called moral rights, which is more of an ideal plane of rights. The most important one is that as a composer, you can claim the authorship of the piece. And the authorship is what qualifies you in all the practical rights. So if you're the creator or author, as they often say in copyright law, you have the right to decide on everything to do with performing, monetizing, modifying, and distributing your piece. So be aware of this. This is an important right that doesn't seem important in the big picture, but it really is. It's what puts you at the top of the pyramid. Another right that you have is, because you're going to be at the top of the hierarchy, let's say, for this piece that you created, you have the right to object to any modification of the piece and to object to any derogatory action. So modification is, for instance, a cover song and or any other performance that will modify your piece. Anything that will make the piece something else, even if it's just one note that it switched, you have the right to object to that. The other thing you have the right to object to is something called derogatory action, which is basically something that will pull you down from the top position in the hierarchy of the piece so that you get less power over the piece. It can also include anything that will discredit you in your role as a creator, or that will, for instance, weaken your reputation or your general standing. So be aware of this. You have the right to object to these actions by other people, like a record label, for instance. And the way you object is by, when you sign the contract, you negotiate. So there are some exemptions to the rules of copyright, and they're usually found in the Berne Convention, and then they can be modified by national law in the sense of they can be made stricter. Citations is an important exemption. This is mainly in academic work. Anything to do with academic or educational purposes and research is an exemption, but this has to be a true academic and educational purpose that has nothing to do with commercial values. And I know recently, for instance, Rick Beato was very angry that he was not allowed to play certain pieces in his YouTube videos. But actually that is to do with the fact that he is a commercial actor who's trying to have a career doing what he does. And there is a big difference between education that is commercial or private and education that is in a public institution or a publicly accepted institution like a private university. So be aware of this. This is an exemption to your stance as a composer if someone else wants to analyze your work for, say, research. There is an exemption for library and archival use, just so that it's accessible to the public as a historical source, in a sense. There are also exemptions for accessibility needs, so that maybe something needs to be modified in your piece to be accessible in some way. In the US and in Israel, they also have something called fair use, which is an exemption to the Berne Convention. And it means that you have to use some discretion in considering whether an exemption should be made or not. So if it has to have some form of public interest to be qualified for fair use. And then in the EU, for instance, there are less exemptions, and it's much stricter on the exemptions situation than in the rest of the world. For instance, in the Berne Convention, a creator is protected 50 years after their death, and that's when the copyright stops. Whereas in the EU and Europe and EEA, it's 70 years after the creator's death. So just to be aware of, if you're based in Europe, there are even less opportunities to make exemptions to your right as a composer. Okay, this was a lot of principles. I've tried to make it accessible, but if you do have any questions, feel free to reach out to me on Twitter. I'm at Tinelinen, which you'll see here. And stay tuned for part 2, when we are actually talking about what you can do to protect yourself in this world of the internet. I hope you enjoyed it and that you got some useful information out of this, and I'll see you next time.